Company versus Dodgers County Commission, case number 12C17. Are you ready?
Yes, Your Honor.
Good morning. Good morning.
How you doing?
Good, how are you, Mr.
Good. Well, a little bit like the old home week. I haven't seen Mr. Wyndham in quite a while. And yourself?
All right, the party will identify themselves and their representation for the record, please.
David Anderson and Steve Hastings on behalf of EQT.
Donald J. Tennant, Jr., T-E-N-N-A-N-T, representing Dodgers County Commission.
William C. Thurman, Counsel for Joy Huff trustee, and William Huff, and also seated at the council table with David McMahon and David Richardson.
Brad Stevens, S-T-E-P-H-E-N-S, appearing on behalf of the prospective interveners James Foster and Jenny Foster.
All right. I know that some of your clients are here as well. Would like to identify them for the record, please.
EQT is here, Your Honor, on behalf of 520 Bowden. And we have several witnesses as well.
The Dodgers County commissioners are available, one in the building, one 5 minutes away, and one 15 minutes away. And we had agreed previously as gentlemen that if they were to be called, that we'd have notice to call in by cell phone and have them all here in due time.
Thank you, Mr. Tennant. Thurman?
Your Honor, my client Joy Huff as trustee is present.
Your Honor, I have with me today James Foster and Jenny Foster is also present.
All right, very well. Apologize for the late start. Some criminal matter came up, which take priority we had to deal with. I wanted to disclose to council on the record for council's consideration. In reviewing this matter, it came to my attention that several years ago I prepared a deed for the Huffs with regard to the Dodgers County real estate. I believe at that time it was a deed involving the trust. There was a lawyer-client relationship there with the Huffs. As I recall, that was the total extent of it. It has terminated long ago, and there are no outstanding issues involving that relationship that I'm aware of at this time. I just want to make the parties aware of that because obviously if somebody looked at the deed in the record room, it's going to clearly appear that I prepared it. And in the event that any of the parties felt that that was an issue, I wanted to bring that up so you can be aware of that and make a decision in that regard.
Yeah, I think you disclosed that to us before, Your Honor. We had no problem.
No objection by the Dodgers County Commission.
No objection by proposed interveners Joy Huff as trustee and William Huff.
Your Honor, no objection by prospective interveners James Foster and Jenny Foster.
All right, very well. Let's take up the motion to intervene. All right. Yes, sir.
Your Honor, it's a matter of housekeeping. Do you require us to go to the third room? Can we?
You can speak from the council table if you want, as long as you speak up and everybody can hear.
Right.
I'd like to do that then, Your Honor.
That'd be fine, Mr. Chairman.
May it please the court, Your Honor, we're here today upon proposed intervener's application of petition for intervention in this matter. As the court is well aware, Rule 24A, respecting mandatory intervention, has 4 prongs. The first is that the application must be timely, and in this case, our application was filed before this court on May 17, 2012. The second prong is that we must claim an interest relating to the property and transaction which is the subject of this action. The third is the disposition. In this case, may impair my client, the Huff's ability to protect their property interest, and we assert that a wrong disposition here could expose them to greatly enhanced flooding. The fourth prong would be that my client's interest is not adequately represented by the existing parties, EQT, and the Dodgers County Commission. From our memorandum filed in this matter, Your Honor, citing the Ball case, it's expected that a liberal view towards allowing intervention should be followed. We assert that the Huffs and the Fosters have met all 4 standards, and our motion to intervene should be granted. With respect first to timeliness, this court has made no substantive rulings, and we filed our petition on May 17th, quite a while ago. The second prong, indeed, no parties anywhere have any greater property interest than my clients, the Huffs and the Fosters, which are also addressed in our memorandum. Citing Shenandoah River Keeper and Potomac versus Ox Paperboard, interests in property are the most elementary type of right that Rule 24A is designed to protect. Your Honor, the proposed activity, 12 wells in the Huff's Meadow with a well pad containing 60,000 cubic yards of fill in the floodplain and floodway, and immediately immediately upstream. Back up. The proposed development is immediately downstream to Foster's, basically creating a dam or dike can only create raised mean flood levels in the meadow, affecting the Huff's house and immediately upstream to Foster's. The third prong, Your Honor, is that my clients may be practically disadvantaged by a decision here. It's clear and obvious. Reinstating the flawed permit and allowing development in that meadow and floodplain would authorize unlawful activity under the Dodgers County floodplain ordinance. The highest purpose we suggest of that ordinance on its face is to prevent or minimize future flood damage. The fourth prong, Your Honor, is absent intervention, the Huffs and the Fosters will not be adequately represented. Clearly, we don't expect and never would expect the plaintiff EQT to do that. The defendant, Dodgers County, has demonstrated a failure to represent the interveners by issuing a permit which violated their own floodplain ordinance. There was no effective review. Essentially, the application was rubber stamped. The permit which we assert should never have been issued was only thereafter corrected when FEMA personnel identified various violations, and only then was the permit revoked. Your Honor, the general interest in public safety in the floodplain and in the floodway is clearly the purview of the County Commission. More importantly, we believe the specific, direct, personal interest is with the Huffs and Fosters and what happens to and on their property. We believe that the Huffs and Fosters have met the 4 prongs required in Rule 24A for mandatory intervention. If the court should not grant the mandatory intervention, then the court has, pursuant to Rule 24B, the opportunity to grant permissive intervention, which, when granted, is certainly within the sound discretion of this court. 2 prongs are required under permissive intervention: a timely application, and when the intervener's claim or defense in the main action have a question of law or fact in common. And all that should be liberally construed in favor of the proposed interveners. Your Honor, the proposed interveners' cross-claim against the County Commission makes both state and federal due process claims. Procedural due process claims, basically the fundamental right to notice and an opportunity to be heard whenever and wherever a government action can reasonably affect property rights. The Huffs and Fosters' claims for increased flood damage share common facts regarding the proposed construction of the floodplain, in the floodplain and floodway by the wellhead. Your Honor, we believe it is a timely petition with common questions of law and fact, and suggests that liberal construction of Rule 24B for permissive intervention is satisfied, and therefore our motion to intervene should be granted. I draw the court's attention to the fact that the defendant, Doddridge County Commission, has in fact recognized that the Huffs and the Fosters are real parties in interest. The Doddridge County Commission, as a defendant, has no objection, and in fact, their response has been to encourage this court to permit that intervention. In reviewing EQT's argument opposing our intervention, they state and assert that the floodplain ordinance procedures were not followed. Well, we agree with that. Essentially, we would first assert that the paper signed by Commissioner Evans was not really a permit. The ordinance requires that the County Director of Emergency Services is the floodplain administrator, and it's the duty of the floodplain administrator to review and to approve or disapprove a permit application. When the permit was signed by Mr. Evans, the OES director was not Mr. Evans as a commission. The County Commission didn't take any action to amend their ordinance to allow Commissioner Evans to serve in the capacity as OES director. And essentially, we believe the paper that's purported to be a permit confers no rights to EQT because Commissioner Jerry Evans had no authority to issue a permit under the ordinance. Your Honor, the final decision of the Doddridge County Floodplain Appeals Board admits that the ordinance procedures were not followed. There was no site visit, no thorough review. EQT's application was deemed insufficient and not in compliance, and the permit on its face has expired. Neither the general public nor proposed interveners Huffs and Foster have been protected by the Doddridge County Commission in that regard. Your Honor, there are some practical reasons. Basically, the argument between EQT and Huffs and Fosters is not if drilling should occur on the Huff property, but where that drilling should occur. Evidence will show that the Huffs have 640 acres. That's 1 square mile under lease to EQT. And yet they only seek to protect the 10 acres of meadow and have repeatedly offered to work with EQT to find a site on the remaining 630 acres out of the floodplain and out of the floodway. Your Honor, the Fosters want to avoid the damming or diking of the stream, the adding or the addition of 60,000 cubic yards of fill, which would make floods much worse for them. Both parties are here seeking to protect their property rights, and the county commissioner's actions have been, at the very least, less than adequate to accomplish the protections that Huffs and Fosters seek. In summary, Your Honor, in the memorandum we cited the case of law, and it's clear on the facts are here in this case. The requirements for both mandatory intervention are met. The elements of permissive intervention are clearly present. The defendant, Doddridge County Commission, recognizes that Huffs and Fosters are real parties in interest, and to grant intervention in this case is the proper thing to do each and every respect. Accordingly, we urge the court to grant intervention for the Huffs and the Fosters. Thank you, Your Honor.
Thank you, Mr. Thurman. Mr. Tennant, do you desire to speak in support of the motion?
I'd like to publicly state in court that we filed a pleading in this matter with this regard, that the Dodgers County Commission has no objection to the intervention and actually encourages the court to do so, so that the real parties in interest to this dispute are present and available to make argument and present evidence.
Thank you, Mr. Tennant.
Mr. Hayes, Steve Hasty, John, Your Honor, with all due respect to Mr. Tennant, the real party of interest in this case is EQT Production Company and the Dodgers County Commission. The motion to intervene should not be granted for any of the proposed interveners under either mandatory or permissive intervention. Mr. Thurman talked about the fourth prong, and we go through it quite simply. With respect to timeliness, did they file a motion to intervene after we filed a complaint in this manner? Yes, Your Honor, but they knew more than a month before the rescission on April 17, 2012, of our floodplain permit, of the fact we had a floodplain permit. Their own admission takes them beyond that 30 days, and they knew probably in February, because the DEP informed them of the fact we had a floodplain, so we consulted with the floodplain administrator and with Dodgers County and completed a floodplain study. And actually, our well application, which was filed in November of 2011, advises these proposed interventions of the fact that we would be likely consulting with the floodplain coordinator for the county on these issues. So as far as timeliness goes, Your Honor, we don't believe they need timeliness. We believe they waived their right to complain about the process within which we got our application, what we did fill out, the decisions of the floodplain administrator beginning, and then the calamity of events that happened after that. With respect to the interest related to the property, Your Honor, Mr. Thurman said something key. They're not contesting whether we're entitled to drill. They're contesting where we're entitled to drill. Their property interest in the drilling itself is surface damages. The law provides them a remedy for that. They have no greater or no lesser property right, regardless of what this court does on the floodplain permit issue. We're entitled to drill. And if we take the surface, we pay them for that. There's statute, West Virginia law is clear. The court also needs to recognize that their property interests are subservient to our property interests, to EQT's property interests, because EQT in the mineral interest is a dominant estate here. So that's important for the court to remember as we go through this process and with respect to motion intervention. They don't have, as the Ball case cites, a direct interest in such a direct and immediate character that they will either gain or lose by the direct legal operation and effect of the judgment. Your Honor, we will put on evidence that there are no other reasonable alternative locations for these wells. That aside, if we put the wells in location A or location B, they're still entitled to damages. They won't gain or lose. They have no direct interest. And, Your Honor, this claim is not even pending in this case. This case is filed by EQT because of what the Dodgers County Commission did. The sole issue for the court is whether they follow proper procedures, follow the floodplain ordinance, follow the Open Government Proceedings Act, violate due process, and comply with the ordinance to either grant or deny permit. Has nothing to do with their claims for some abstract potential surface damage that may be in the future. Which transitions us to the third problem. Disposition of this case will not impair their ability to protect their property interests. Your Honor, they have rights to damage under the surface damage statute. If they're allowed to intervene, what they're going to do is cloud the issues. Mr. Thurman's argument was a lot of issues that have nothing to do with whether the EQT can file floodplain limits, and that's what's going to happen in this hearing if they're allowed to intervene in this case. They can take appropriate action to protect their property interests in the event that we take surface, which we're entitled to do. If we damage surface, we run over a fence, Your Honor, you got to pay for it. It's that simple. Their interests are not impaired by keeping them out of this case. The fourth prong of mandatory intervention, Your Honor, is whether their interests are adequately represented. The interest, the remote interest that the proposed interveners have is any damage to their property. Your Honor, those interests are protected. They're protected by the legislature and the surface tenure statute. The Dodgers County Commission is represented by counsel. Mr. Tennant, I'm sure, will come up and he'll cross-examine the witnesses when necessary to convey to this court, or attempt to convey to this court, that what the county commission is property. The issue for the court in this case is whether what the county commission did was proper. Not whether there's circumstances, not whether there's reasonable alternative locations. It's whether EQT satisfies the requirements of the floodplain ordinance and whether their due process rights were violated. The proposed intervener's main claim in this proposed intervention, the proposed answers that they filed with the court, is that the floodplain ordinance itself is unconstitutional. Your Honor, that issue is not before the court in this case. The proposed interveners want to contest the constitutionality of this ordinance. They can go to the Dodgers County Commission, which they've done on numerous occasions, to try to get things changed. They can file a separate action with this court. They can work to replace their county commissioners if the county commissioners don't want to take action. There are many things they can do to amend, modify, or change the floodplain ordinance. But the constitutionality of that ordinance is not an issue. So you don't think that they meet any of the prongs of the mandatory intervention rule, Rule 2402, and it really, with respect to property interest, the rights are not impaired, and the rights of the public in general are represented by Mr. Tennant. With respect to permissive joining, I won't reiterate the timely application before Your Honor already made that argument. The second prong is the intervener's claim is a question of common law or fact issue in this case. Well, I just told you, Your Honor, that their claim is the constitutionality of the ordinance. It has nothing to do with whether we comply with the floodplain ordinance. Mr. Thurman made some representations before Your Honor, but I think the evidence is going to bear out different today. EQT did do a floodplain study. They did provide that information. FEMA never told the Dodgers County Commission that we're in violation of either the floodplain ordinance or anything else. That's just flat out wrong. The only person that told the Dodgers County Commission anything is Kevin Sneed. Mr. Sneed's here today, and he's going to testify what he did. Mr. Sneed is a state coordinator. Now, he works with FEMA, and he's going to tell the court that FEMA says our floodplain is okay. We did a floodplain study. Our engineers provided information to Mr. Sneed. He ran that by FEMA. Not just anybody at FEMA, Your Honor. Engineers at FEMA. 27 years experience. And FEMA says it's okay. So the issues in this case are whether the Dodgers County Commission violated floodplain ordinance, violated the Open Government Meetings Act, which I think everybody's going to agree with that, Your Honor. I think that's clear. It's not the constitutionality of the statute. Finally, with respect to whether the permit, the paper was, the actual permit was had any effect, and whether it expired, and those issues, Your Honor. Those are issues that Mr. Tennant is going to address, and we're going to address. None of that would have been an issue had the Dodgers County Commission followed the rules, procedures, and the Open Government Meetings Act. And I will end with this and remind the court that they have no greater or less property interest if you do not allow them to intervene in this case, because they have the rights to their service standards under Western law. Thank you.
Thank you, Casey. Anybody else have anything? Yes, sir.
Your Honor, Dean Richardson for the Hubs, the trustee and just briefly would like to go back to the statement by the court.
You may.
Thank you. As to the timeliness argument by EQT, I would just like to say that EQT seeks to expand the scope of Rule 24A from entering into an action, i.e. a lawsuit, into the entirety of the proceedings. EQT wants to take back all the way back to November, apply everything that's happened since then to today. First of all, the rule itself states action, clearly. It doesn't say entirety of the proceedings. Second of all, if Your Honor takes a look at the Ball case, the entirety of the proceedings there were well over a year. And in fact, 2 months went by before the interveners joined in the case. In my experience, at least, most lawsuits have a backstory. The purpose of intervention is for when the backstory becomes actual litigation, the third party is left out, that the third party has a means to intervene in the litigation. As for the interest in property, and again, I'd like to cite Justice Bailey, it's well established that interest in property is the most elementary type of right that Rule 24A is designed to protect. We're also stating, citing the federal rules of civil procedure, I quote Ball in saying we give substantial weight to federal cases in determining the meaning and scope of our rules of civil procedure. Further, I'd like to clear up one misstatement in our motion to intervene regarding the distance of the proposed site to the Huff Farm house. It's not 300 yards, it's 300 feet. And real property damage is not the only thing that's a concern here. And there's no guarantee that the Huffs will get service damages. EQT acts like it's an automatic thing. There's personal property at stake, there's livestock potentially at stake in the event that it does flood. There's potential for human life to be at risk. There's more at stake here than surface damages or aesthetics. As for the third prong, mandatory intervention may be practically disadvantaged by the disposition of the action. This is satisfied. They want to put wells in tens of thousands of cubic yards of fill in a floodplain directly across the street from my client's farmhouse. They want to take my client's only meadow. Further, in terms of practical implications of civil procedure, this could potentially act as res judicata if my clients want to bring cross claims for another action, if there's ongoing litigation, which there is. EQT would be able to cite this ruling that the floodplain ordinance was properly granted and we weren't allowed to intervene, and it would impair my client's rights. Further, if in a practical manner, if the intervention is not given, my client will be forced to bring a separate cause of action. If that isn't a practical disadvantage, I'm not sure what the practical disadvantage is. As for lack of adequate representation, counsel for the county has already stated he wants us in, and he has no opposition to our appearance in this case. EQT obviously isn't going to represent our interests. We're here solely because the county did not represent our interests by following their own ordinance. As to the comment that in the motion that, and I believe Mr. Hastings referred to it, that the Huffs seek to expand the scope of the litigation. This is about the validity of the floodplain permit. It's not expanding the scope. Even if the scope is expanded in some way, if you see Ball, there is a solution to that. You can bifurcate the action. A mandatory damages, a monetary damages claim can be bifurcated. There are ways around it beyond just denying my client to intervene in the action. I would like to clear up just a couple of things. I see that with FEMA representative, Mr. Sneed is consistently quoting and saying that the floodplain permit or the floodplain study is good to go. Well, the actual quote is appears. He qualifies his endorsement of the plan in the email to Mr. Hastings. And second, Mr. Hastings himself said the first issue in this case is whether Doddridge County violated the floodplain ordinance. That's our contention. Doddridge County violated the floodplain ordinance. EQT's contention. Doddridge County violated the floodplain ordinance. That's all we are here to argue about, is whether the floodplain ordinance was followed. And regarding substance and procedural due process, and that sounds a lot like EQT's argument in Mr. County at the moment as to the floodplain. As for the permissive intervention, I just stress again that we put take a liberal view, and as to the common nucleus facts of law, again, and not to bemoan the point, we are arguing about the validity of a floodplain permit. Everyone is arguing about the validity of a floodplain permit. I thank Your Honor for your time.
Very well.
Your Honor, may I respond briefly?
You may.
Your Honor, EQT Production Company is arguing regarding the validity of the floodplain permit. Proposed interveners are arguing about the validity of the floodplain ordinance. Just to respond briefly to several things Mr. Richardson said. Let's talk about the loss of potential cattle in the meadow. Your Honor, the surface damage statute covers that. Anything we cause them losses, Your Honor, my client caused them losses, they got to pay for it. It's as simple as that. You take the meadow, Your Honor, EQT has to pay for that. I'm going to quote Ball, Your Honor, at 208 West Virginia 400. Direct and just has been described as one of such direct and immediate character that the intervener will either gain or lose by the direct legal operation and the fact of the judgment to be rendered between the original parties. Said another way, a person has a direct interest justifying intervention in litigation where judgment in the action itself adds to or distracts from his legal rights without reference to rights and duties not involved in litigation. Your Honor, they're not allowed to enter in this case, but rights regarding their property interests are not affected. It's not added to or taken away by this decision. Your Honor, Mr. Richard talked about consolidating, or I think that's what he's trying to argue, and saying that monetary damages claim to be bifurcated. You know, they haven't sued us for monetary damages for surface damage yet. There are no surface damage yet, Your Honor, because we haven't been able to do anything on the property. So there's nothing bifurcated. If they want to file another action and maybe join it in here, we'll come back and argue that a different day. But that's not the issue here today. They don't meet the requirements of mandatory intervention. They don't meet the requirements of permissive intervention. Thank you.
Any parties have anything further? All right, carefully consider this matter in the arguments of counsel, and the court will find that the interveners do come within the requirements set forth in Rule 24A. They do have an interest in the subject matter of these proceedings, which in fact have to do with potentially the issuance of an injunction for purposes of requiring the county commission to recognize or issue or preserve as valid a permit to drill in the floodplain. If this case were simply a case of drilling on a hill out of the floodplain, then the issues would be as you suggested, I believe, Mr. Hastings. However, that's not the case. The wrinkle in this case and what distinguishes it from the general body of law dealing with the surface owner's right to recover based upon the exercise of the mineral estate, the enjoyment of the mineral estate, are just limited and incomplete. So because the nature of these proceedings is such that the Huffs and Fosters are adjoining landowners, the Huffs in the sense that they adjoin the mineral estate, and Fosters in the sense that they are downstream, are interested in whether or not this permit would either stand or fall pursuant to the proceedings that we're here today to take up. So obviously I preserve EQT's exceptions to that ruling, but the Huffs and Fosters are proper and shall be permitted to intervene in this case, having come within Rule 24A and the requirements thereof. Now, I think we also have scheduled for yes, sir.
I believe in the restaurant, but our position would be that the next thing that we should take up would be the motion for summary judgment. We've already filed.
Well, Mr. Henderson,
Your Honor, that's the craziest position I've ever heard in my life. I mean, he sent me an email over the weekend on Saturday, which caught my attention. I've had that with numerous emails, but this one caught my attention because he wanted to know if we were going to respond to his motion for summary judgment. And I told him I knew of no body of law that required us to respond to allow him to file a motion for summary judgment in a case he wasn't even a party in yet. And then I told him that I didn't think I was required, or my client was required, to file a response to a motion for summary judgment from someone that wasn't in the case yet, and challenged him to send me any case law he had on that point which supported his position. We haven't responded to it. If you didn't grant their motion, then obviously it's a moot point. Now that you did, surely the court will grant us leave for time to file a response to motion for summary judgment, which I assume the court understands we will vigorously oppose.
I understand. You may respond.
The rule provides the motion to be made orally, so at any time the court would renew the motion, make it orally in court. He can't say that he didn't have notice of it. He chose to put his eggs in the basket of not responding, and hoping that we didn't get intervention, and we should be able to proceed. Because our position is that the permit was not valid in the first place because our clients didn't get notice. And if that's true, then all of the rest of this doesn't even have to have the hearing, doesn't even have to have all the evidence, because it wasn't valid in the first place. So whether or not it was validly later revoked is moot.
Well, Mr. McMahon, I guess the biggest issue I had was I don't believe it was sent that day. I think it was just generally filed. And normally I would, being conscious and aware of due process, permit the parties to have an opportunity to respond and develop based on